Hello everyone! Here are the Group 1.
Hi, I am Jane, and I am a police officer.
Hello everyone, especially to my fellow future lawyers in the field. I am Ms. April Rose Canieto Aguila. I work as a school secretary and a teacher.
My name is Maxine Grace Mendoza and I am a full-time student.
Hi everyone, my name is Noruden Mandi, a government employee.
And I am Ravi Tio, a teacher by profession. And we will be discussing chapters 9, 10, and 11 in this video. So please listen!
Article 9 of the 1987 Philippine Constitution contains the provisions of the constitutional commissions, in which each has its own function, jurisdiction, and prohibition. How do they differ from each other? Based on their qualifications, term of office, and decisions. We will answer all of this in this video. The three constitutional commissions under Article 9 are the Civil Service Commission, known as the CSC, the Commission on Election, or the COMELEC, and the Commission on Audit, or the COA. These commissions are atypical with the three major organs of the government because they are clothed with quasi-legislative, executive, and judicial functions. Likewise, they are independent from the will and pressure of the three major organs of the government. Now, let us discuss the attributes that guarantee the independence of these commissions. First, they are constitutionally created, therefore may not be abolished by a statute. Second, each is conferred certain powers and functions which cannot be reduced by a statute. Third, chairmen and members are subject to certain disqualifications calculated to strengthen their integrity. Fourth, salaries of chairmen and members are fixed by law and shall not be decreased during their tenure. Fifth, commissions may appoint their own officials and employees in accordance with civil service law. Sixth, commissions enjoy fiscal autonomy, in this sense that once approved, it should be automatically and regularly released to them. 7. Each commission and bank may promulgate its own procedural rules, provided that they do not diminish, increase, or modify substantive rights. 8. Chairmen and members are given fixed term of office of 7 years without reappointment. 9. Chairmen and members may not be appointed or designated in a temporary or acting capacity. 10. Chairmen and members cannot be removed except by impeachment or upon the expiration of their term. The common prohibitions on members of the constitutional commissions. These prohibitions are: first, hold any other office or employment. Second, engage in the practice of any profession. Third, engage in the active management and control of any business which in any way may be affected by the function of his office. Fourth, be financially interested, directly or indirectly, in any contract with or any franchise or privilege granted by the government, any of its subdivisions, agencies, or instrumentalities, including GOCCs or their subsidiaries. Without further delay, let's move forward in the term of office of each commission. For both CSC and COA, the provision read as follows. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, a commissioner for 5 years, and another commissioner for 3 years without reappointment. Appointment to any vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. For the COMELEC, the chairman and commissioners shall be appointed by the President with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, 3 members shall hold office for 7 years, 2 members for 5 years, and the last members for 3 years without your appointment. Appointment to a vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Now, let's have a closer look on each commission, starting with the Civil Service Commission. The CSC is the central personnel agency of the government. It is tasked to strengthen the merit and reward system in the civil service by administering and enforcing the constitutional and statutory provisions on the merit system for all levels and ranks in the civil service. As the central personnel agency of the government, it establishes a career service, adopts measures to promote morale, progressiveness, and courtesy in the civil service, strengthens the merits and rewards system, integrates all human resources and development programs for all levels and ranks, institutionalizes a management climate conducive to public accountability. The Constitution adopts the merit system to ensure that those appointed in the civil service are competent. This is to eradicate the system of appointment to public office based on political considerations and to eliminate the element of partisanship and personal favoritisms in making appointments. The Commission on Audit, or the COA. It is the watchdog of the financial operations of the government. Sees to it that the government funds are well accounted for and that they are spent in accordance with the appropriations law. In addition, it also has auditing authority over the government or any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations with original charters. It also has post-auditing authority over the following. First, constitutional bodies, commissions, and offices that have been granted fiscal autonomy under the Constitution. Second, autonomous state colleges and universities. Third, other government-owned or controlled corporations and their subsidiaries. And lastly, such governmental entities receiving subsidy or equity directly or indirectly from or through the government. As the watchdog of the government, it has the following powers and functions. First, examine, audit, and settle all accounts pertaining to the revenue and receipts of and expenditures or uses of funds and property owned or held in trust by or pertaining to the government. Second, keep the general accounts of the government and preserve the vouchers and other supporting papers pertaining thereto. Third, authority to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures or uses of government funds and properties. The Commission on Audit is composed of a chairman and 2 commissioners with the following qualifications. First, natural-born citizens of the Philippines at the time of their appointment. Second, at least 35 years of age. Third, certified public accountants with not less than 10 years of auditing experience or members of the Philippine Bar who have been engaged in the practice of law for at least 10 years and must not have been candidates for any elective position in the election immediately preceding their appointment. Each commission shall decide by a majority vote of all its members in any case or matter brought before it within 60 days from the date of its submission for decision or resolution.
The Civil Service Commission. The Civil Service Commission is the commission tasked to strengthen the merit and reward system in the civil service by administering and enforcing the constitutional and statutory provisions on the merit system for all levels and ranks in the civil service. Presidential Decree No. 807, otherwise known as the Civil Service Decree of the Philippines, declares that the Civil Service Commission shall be the central personnel agency of the government to set standards and to enforce the laws and rules governing the selection, utilization, training, and discipline of civil servants. Civil service means that professionalized body of men and women who have made of the government service as a lifetime career. It has also been used to refer to that portion of the public service that is governed by the merit principle in the selection of officers and employees. The merit system, you may wonder, is a system wherein merit is determined through competitive examination. So, as a general rule, the selection of appointee to any government position shall be made only according to merit and fitness, to be determined as far as practicable by competitive examination. This is very important to ensure that recruitment of government personnel is not to be made on the basis of an indiscriminate or whimsical method on selection, or on consideration of friendship, kinship, partnership, or social connections. But what happens when competitive examination is not practicable? Other methods of determining merit and fitness may be resorted to, such as by an investigation of school records, experience in actual work, achievements of a character relevant to the position to be filled, and such other tests modern educational science may produce. The Presidential Decree No. 807 also enumerates the powers and functions of the Civil Service Commission, such as: first, establishes career service; second, adopts measures to promote morale, progressiveness, and courtesy in the civil service; third, strengthens the merit and reward system; fourth, integrates all human resources and development programs for all levels and ranks; and fifth, institutionalizes a management climate conducive to public accountability. The Civil Service Commission is created for the following purposes. 1. Adopts the merit system to ensure that those appointed in the civil service are competent. 2. Eradicate the system of appointment by political considerations. And 3. Eliminate the element of partisanship and personal favoritism. Jurisdiction of the Commission. A government-owned control corporation or GOCC created by a special law are subject for civil service. Disciplinary cases and cases involving personal action, including appointment, promotion, transfer, reinstatement, re-employment, detail, reassignment, demotion, and separation are within the exclusive jurisdiction of the Commission, with the exception of those branches that are incorporated with the Corporation Code. The Civil Service Commission are composed of 3 members, 1 chairman and 2 commissioners. A qualified member of the Civil Service Commission must be, first, a natural-born Filipino citizen; second, they must be at least 35 years of age at the time of their appointment; third, they must be persons with proven capacity for public administration. Unlike Commission on Election, knowledge of law or experience in the practice of law is not required, presumably because the position calls more for administrative ability rather than legal competence. And lastly, they must not have been candidate for any elective position in the elections. Members of the Commission shall be appointed by the President with the consent of the Commission on Appointment. The Chairman shall hold 7 years without reappointment. A Commissioner shall hold 5 years. Another Commissioner shall hold 3 years. The scheme of rotational appointment is intended to give continuity to the Commission by allowing the term of only 1 Commissioner to expire every 2 years. On the basis of appointment, the Constitution classifies position in the civil service into 2 principal groups: competitive position and non-competitive position. Competitive position, it is done according to standard merits and fitness to be determined by competitive examination. Non-competitive position, it does not need competitive examinations under this authority. They may hire candidates without having to go through the full application process. next in rank rule, or otherwise known as rule of preference. The employees next in rank are those who occupy the next lower positions in the occupational group under which the vacant position is classified, and in other functionally related occupational groups and who are competent, qualified, and with the appropriate civil service eligibility. Distinction between career and non-career positions as to entrance, security of tenure, and opportunity for advancement. Now, in career positions, the entrance is based on merit and fitness. They are also entitled to security of tenure, and there is an opportunity for advancement. While on non-career positions, entrance is based on other matters than the usual test. It does not require security of tenure, and there is no prohibition for a non-career service employee to be appointed to a career position. Temporary appointment is considered as a non-career position. As such, they are not protected by security of tenure. Thus, they can be removed anytime without cause. An abolition of office may be brought about by reasons of economy or to remove redundancy of functions, or a clear and explicit constitutional mandate. Government employees are also entitled to certain rights, such as they shall not be removed or suspended except for cause provided by law. Second, they have the right to self-organization. And third, they shall be given such protection as may be provided by law. There are also certain prohibitions for government employees. First, they must not engage into partisan political campaign or political neutrality of civil servants. If the civil servant is to discharge his duties faithfully, impartially, and efficiently, he should not be beholden to whatever political party is on the saddle. Second, they must not be designated to any public office during his tenure. Now, this refers to ineligibility for appointment of elective officials. This is in reference to Section 7 of Article 9B of the Constitution, which seeks to minimize the so-called spoils system, the practice by which public officers or public offices are distributed among the members of the victorious party, the relatives, and supporters. During his tenure in office, any elective official is disqualified for appointment or designation to any public office or position, whether national or local. He may be appointed provided that he forfeits his seat. Third, they must not receive additional, double, or indirect compensation. This is designed to counter the evils of double compensation. Double compensation produces unemployment because it excludes other person from the service and results in inequalities in compensation. Fourth is ineligibility for appointment of defeated candidate in an election. A candidate who has lost in an election is likewise disqualified for an appointment or reappointment to any office in the government. The purpose of the disqualification is to stop the practice whereby one with political connection aspires for an elective position with the hope that even if he should lose, he could still be appointed to an office or reinstated to his former position in the government. Now, we are going to talk about the Commission on Elections, or simply the COMELEC. So, what is COMELEC? COMELEC is a constitutional commission which safeguards the republicanism and democracy of the state. How? Through the conduct of elections. It is the commission which ensures the safety and sanctity of ballots, being the expression of the will of the people. The Commission on Election is composed of 7 members, 1 chairman, and 6 commissioners. The Constitution also provides for the qualifications of these members. First, they must be natural-born Filipino citizens. Second, they must be at least 35 years of age at the time of their appointment. Third, they must be at least holders of a college degree and must not have been candidates for any elective position in the immediate preceding elections. Other qualifications provide that majority of the members, including the chairman, must be members of the Philippine Bar and must have been engaged in the practice of law for at least 10 years. Members of the COMELEC are appointed by the President with the consent of the Commission on Appointment. They serve for a term of 7 years without reappointment. Take note that no members of the COMELEC shall be appointed or designated in a temporary or acting capacity. The Commission on Elections has the power to hear and dispose of election cases. They may sit en banc or in two divisions. The Commission is also empowered to promulgate its own rules of procedure in order to expedite the disposition of election contests. The Commission on Elections performs executive and judicial functions. The specific powers of the Commission are enumerated in Section 2, Article 9C of the Constitution. First is the power to enforce laws relative to the conduct of an election, plebiscite, initiative, referendum, and recall. This refers to the power of the COMELEC to annul or cancel illegal registry lists of voters, to order the preparation of new lists of voters, to suspend the proclamation of winning candidates with questionable victory. Second is to decide election contests. Now, an election contest exists when a defeated candidate for an elective public office questions the right of the proclaimed elected officer. So, the COMELEC has to ascertain the candidate lawfully elected to office. Jurisdiction over election contest. Election contests involving regional, provincial, and city officials are placed under the exclusive jurisdiction of the Commission on Election. Election contests for municipal and barangay officials are under the jurisdiction of regional trial courts and municipal trial courts respectively, subject to appeal to the Commission whose decision or rulings are final, executory, and not appealable, subject to certiorari review by the Supreme Court. Third is the power to decide all questions affecting elections. However, the Commission has no jurisdiction over questions involving the right to vote. These questions involving the right to vote includes 1. Qualification and disqualification of voters. Second, the right of a person to be registered as a voter. Third, the right to cast his vote. And fourth, the validity of his ballot and other allied questions. These questions shall be decided by ordinary courts. Fourth is the power to deputize law enforcement agencies, which should be with the concurrence of the President, since such agencies are under his jurisdiction. The electoral duties of law enforcers are to ensure that peaceful conditions are maintained at the polling and counting centers during elections, and that citizens' exercise of their franchise is carried out without fear of coercion, intimidation, violence, or manipulation. So fifth is the power to register political parties, organizations, coalitions, and accredit its citizens' arms. This is one of the reforms intended to make our political system more responsive to the needs and demands of the times. So there are groups which cannot be registered as political parties. One is religious denominations or sects. 2. Those who seek to achieve their goals through violence or unlawful means. 3. Those who refuse to uphold and adhere to the Constitution. And fourth, those supported by foreign governments. There are also grounds for cancellation of registration of any national, regional, or sectoral party, organization, or coalition. 1. It is a religious sect or denomination, organization, or association organized for religious purposes. Second, it advocates violence or unlawful means to seek its goal. Third, it is a foreign party or organization. Fourth, it receives foreign aid. Fifth, it violates or fails to comply with laws, rules, or regulations relating to elections. Sixth, it declares untruthful statements in its petition. It's a party list system. in the two preceding elections for the constituency in which it is registered. In the case of Angladlad versus Comelec, moral disapproval is not sufficient governmental interest to justify exclusion of homosexuals from participation in the party list system. So 6 is the power to file petitions, investigate, and prosecute. The COMELEC has exclusive jurisdiction to investigate and prosecute cases for violation of election laws. It can deputize prosecutors whose actions are deemed to be the actions of the COMELEC unless revoked. 7th, the COMELEC has the duty to recommend measures as would affect more improvements on the election laws, such as those that would 1. Curb overspending, 2nd. Ensure the enforcement of the fair and equal exposure rule for political parties and their candidates, including limitation of places where propaganda materials shall be posted. 3rd, prevent a strong party or candidate from taking undue advantage of the weakness of others. So 8th is the power to recommend removal or disciplinary action of any officer or employer it has deputized. The President may or may not follow the recommendation of the COMELEC, but since the deputization was with the concurrence of the President, it is unlikely that he will disregard the Commission's recommendation. As to officers and employees appointed by the Commission, it can remove them for cause. Lastly, the Commission also has the duty to submit report to the President and the Congress. The report should contain a description on how a previous election, special or regular, plebiscite, initiative, referendum, or recall was conducted. 2nd, what laws or regulations, if any, were violated. And 3rd, they may also make recommendations with respect to flaws or defects it has discovered in the enforcement of election laws. This provision is important because without it, the Commission, of its independence, may refuse to give information at all to other branches of the government. Contempt powers, as defined by the U.S. Legal Incorporated, is the power to punish persons who show contempt for the orders, process, or proceedings of the Commission. The Commission on Elections can exercise its contempt powers only in relation to its adjudicatory or quasi-judicial functions. Supervision or regulation of franchises and permits, grants, special privileges, and concessions. Now this topic covers sections 4 to 7 of Article 9C of the Constitution. Now, let us start with section 4, Regulation of Public Utilities and Media. Regulation of Public Utilities and Media. Now this section is to be exercised for the purpose of ensuring free, orderly, honest, peaceful, and credible election, and only during election period. Seeks to place all the candidates in more or less equal footing in making known of their qualifications and platforms and their opinions in various public issues. It also equalizes their opportunities of winning in the polls. This section also applies to plebiscite, particularly to those relative to constitutional amendments. Section 5. The purpose of this section is to avoid the possibility of the President in granting pardon, amnesty, parole, or suspension of sentence to violators of election laws who may belong to his political party or for other political reasons without the favorable recommendation of the COMELEC. Section 6 of Article 9C encourages the development of more than 2 political parties. As of 2019, there are about 169 political parties listed and accredited in the Commission on Elections official website. These include all the major and minor parties, both on national and local scope, as well as the party lists. Section 7 provides that unless registered under the party list system, as provided by the Constitution, no votes cast in favor of a political party, organization, or coalition shall be valid. party-list system is a mechanism of proportional representation in the bid for a seat in the House of Representatives. They belong to marginalized parties or organizations registered with the COMELEC. Prohibition on block voting. The general rule is that block voting is prohibited, with the exception of those who are registered under a party list system. The election period runs 90 days before the election, whether it is national or local, and shall end 30 days after. However, the COMELEC in special cases may change the duration of the election. Section 10 of Article 9C of the Constitution provides for the protection against harassment and discrimination of the bona fide candidates for an elective position. This is in line with the Bill of Rights. Bona fide candidates refers to those persons who filed for candidacy with a real intention for winning an elective position. Finally, Section 11 provides for the automatic release of appropriations. It is the obligation of the Congress to provide the funds certified by the COMELEC in order to defray or to pay for the expenses in holding an election, plebiscite, recall, referendum, or initiative. And once approved, the funds shall be released automatically upon the certification of the chairman of the COMELEC. That ends our discussion on the Commission on Election.
Hi everyone. Again, my name is Noroden Mandi, and I was assigned to present the first half of Chapter 10, Local Government, from the book Political and Constitutional Law for Students, Barristers, and Lawyers, authored by Edgardo Villanueva II. Okay, let's start with what is local government. Local government refers to a political subdivision of nation or state constituted by law. It has substantial control of local affairs with officials elected or locally selected. Here in the Philippines, we have 4 territorial and political subdivisions. These are provinces, cities, municipalities, and barangays. Each of these are headed by provincial governor, city mayor, municipal mayor, and barangay captain. The Constitution does not recognize a region as a local government unit. That is why there is no political structure provided for regions. However, there are 2 regions which the Constitution allows to have their local autonomy. These are the Cordillera region and the Muslim Mindanao region. But only the Muslim Mindanao region has successfully legalized their local autonomy and now has become the Bangsamoro Autonomous Region in Muslim Mindanao and on its verge of transition to parliamentary type of government. While the Cordillera region failed twice in legalizing autonomy. The principle of local autonomy. What is local autonomy? Local autonomy is the exercise of certain basic powers, especially first, police power, second, power of eminent domain, and lastly, the taxing power. These basic powers are exercised by local government units so as to best serve the interest and promote general well-being of the inhabitants. Basically, the principle of local autonomy is the power of local government unit to run its own affairs. The local government structure of local autonomy is instituted through a system of decentralization. Decentralization is either by decentralization of administration or decentralization of power. Decentralization of administration is where the central government delegates administrative power to local government, while on the other hand, decentralization of power involves an abdication of political power. Here in the Philippines, only administrative powers over local affairs are delegated to local government. In other words, we only exercise decentralization of administration, not power. The national government has not completely relinquished all its powers over local government. The Local Government Code. The Local Government Code is enacted by the Congress as mandated in the 1987 Constitution under Section 3 of Article 10, Local Government. By then, the Congress enacted Republic Act 7160, which shall be known as the Local Government Code of 1991. It is composed of 536 sections. This code shall provide for more responsible and accountable local government structure instituted through a system of decentralization with effective mechanism of recall, initiative, and referendum. It shall also allocate among the different local units their powers, responsibilities, and resources. It shall also provide for the qualifications, elections, appointments, and removal, term, salaries, powers, and functions and duties of local officials. And lastly, it shall provide for all other matters relating to the organization and operation of the local units. This code granted the local government units the power to exercise certain basic powers of the government and possesses a corporate entity representing the inhabitants of its territory. In short, the Local Government Code is the total execution of law for the purpose of giving the responsibility of delivering basic services effectively and reliably to local government unit. The manner of creation of local government unit. As provided in the Local Government Code of 1991, a province, city, municipality, or barangay may be created, divided, merged, abolished, or altered substantially its boundaries. It is either by law enacted by Congress in case of province, city, and municipality, or by an ordinance passed by the Sangguniang Panlalawigan or Sangguniang Panlungsod, which is located within their territorial jurisdiction in case of barangay. And the requisites and limitations for the creation, conversion, merger, etc. are the indicators of viability and projected capacity to provide services, and the other one is plebiscite. In the indicator of viability and projected capacity to provide services, the following are required. First is income, second is population, and third is land area. The specific requirement for income are the following. For province, at least 20 million Philippine peso of average annual income for the last consecutive year. For city, 100 million Philippine peso of average annual income for the last consecutive year as amended by Republic Act 9009 from Section 450 of Local Government Code. For municipality, 2,500,000 Philippine peso of average annual income for the last consecutive year. The specific requirement for population are the following. For province, a minimum of 250,000 inhabitants within its territorial jurisdiction. For highly urbanized city or independent city, a minimum of 200,000 inhabitants within its territorial jurisdiction. For component cities, a minimum of 150,000 inhabitants within its territorial jurisdiction. For municipality, a minimum of 25,000 inhabitants within its territorial jurisdiction. And for barangay, a minimum of 2,000 inhabitants within its territorial jurisdiction. But barangay within Metro Manila and highly urbanized city must have a minimum of 5,000 inhabitants within its territorial jurisdiction. Lastly, for the land area, the specific requirements are the following. For province, an area of 2,000 square kilometer. For city, an area of 100 square kilometer. And for municipality, an area of 50 square kilometer. For the creation of barangay, land area and income are not essential requirements for the creation. Take note that the land area must be continuous unless it compromises two or more islands or is separated by a local government unit. It must also be properly identified by metes and bounds, and it must be sufficient to provide for such basic services and facilities. Another requisites for the creation, conversion, merger, etc. of local government unit is plebiscite. It must have the majority of casted votes for it to be approved. The voting is conducted by the Commission on Election. Supervisory powers over local government units. The Constitution vests the President with the power of supervision, not control over local government units. The President of the Philippines is considered as a general supervisor. As a general supervisor, he shall provide continuing or individual assignments by indicating what is to be done, limitations, quality and quantity expected, deadline, and priorities. Province, city, and municipality exercise direct supervision. Province has a direct supervision to its component city and municipality, while component city and municipality have direct supervision with its barangays. Same goes with highly urbanized city with its barangays. Direct supervision generally means to be physically present or within an immediate distance, such as on the same floor and available to respond to the needs of its inhabitants. The purpose of this is to make governance more directly responsive and effective at local levels. In turn, economic, political, and social developments at the smaller political units are expected to propel social and economic growth and development. For us to understand in details and efficiently the local government, being a law student, I encourage everyone to read the Republic Act 7160 or the Local Government Code of 1991. And that would be all. Thank you.
Our next discussion will be about the topic Powers of Local Government Units. Before we delve into that, they say that questions are better than answers. So I will give you 20 seconds to answer the following questions. Time's up! It's time to check your answers. For those who will get a perfect score, there will be a surprise gift for you. For number 1, the correct answer is letter D, since all of the inherent powers of the state are also powers of the local government units. For number 2, the correct answer is letter A. There are two powers of the local government which are vested by RA 7160 or the Local Government Code, and they are the police power and power of eminent domain. That will give us also the answer to number 3, which is letter C, or the taxing power. because the taxing power is granted or vested by the Constitution itself. So who got perfect? Okay, if you got perfect, here is my prize to you. Congratulations! I hope you like your prize. So going back to the topic, these powers of the local government are not absolute as well. They are also limited. They are requisites and fundamental principles which shall be followed in order to exercise them. Let us go to them one by one, and we'll start with the police power. Okay, bear in mind also that police power is exercised by the local government through the General Welfare Clause. Okay, and this General Welfare Clause is found in Section 16 of the Local Government Code, and it states, every local government unit shall exercise the powers expressly granted, those necessarily implied therefrom, as well as powers necessary, appropriate or incidental for its efficient and effective governance, and those which are essential to the promotion of the general welfare, and so on. The requisites or limitations for the exercise of the police power are, take note of the acronym DEL, okay? Due process means that the means employed are reasonably necessary for the attainment of the object sought to be accomplished and not duly oppressive. Equal protection, on the other hand, means that the interests of the public general, as distinguished from those of a particular class, require the interference of the state. Limited within the territory means that the police power is exercisable only within the territorial limits of the LGU, except for protection of water supply. Lastly, the exercise of the police power must not be contrary to the Constitution and to the laws. So let's recap the four requisites of the exercise of the police power. Remember DEL. D stands for due process, E stands for, L stands for. Okay, very good children. Since you got that already, let's move on to the power of eminent domain. Like the central government or its instrumentalities, local government units may exercise the power of eminent domain and take private property for public use upon payment of just compensation. The following are requisites for a valid exercise of the power of eminent domain by the LGU. Our mnemonic for this one is OPO, or simply, first O. An ordinance duly enacted by the local legislative council must authorize the local chief executive on behalf of the local government unit to exercise the power of eminent domain or pursue expropriation proceeding over a particular property. First P. The taking of private property is for public use, purpose or welfare, or for the benefit of the poor or landless. Second P. Payment of just compensation must be given to the private property owner. And the second O. A valid and definite offer has been previously made to the owner of the property, but the said offer was not accepted. Can we recite all together the requisites for the exercise of the power of eminent domain? Say OPO. O for P. Second P. Okay, very good children. Finally, we go to the last power of the local government, which is the taxing power. Bear in mind that this is the only power of the local government which is granted directly by the Constitution. It is found in Section 5, Article 10, which states that each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of local autonomy, and so on. Now, under the Constitution, the three main sources of revenues of local government are the following. We have the acronym ACES, or A for accrued taxes, fees, and charges. S and U, which is share in the utilization and development proceeds of national wealth within their areas. And the last S, share in the national taxes through internal revenue allotment. Now, the fundamental principles that govern the exercise of the taxing and revenue-raising powers are pure algae, remember that. First, P, that the collection of local taxes, fees, charges, and other impositions shall in no case be left to any private person. And number 2, that the taxation shall be uniform in each local government. Number 3, that the revenue collected shall inure solely to the benefit of and subject to the disposition by the local government unit unless specifically provided therein. Number 4, taxes, fees, charges, and other impositions shall be equitable and based as far as practicable on the taxpayer's ability to pay, be levied and collected only for public purpose, not be unjust, excessive, oppressive, or confiscatory, not be contrary to law, to public policy, national economic policy, or restraint of trade. And lastly, LG, which means that each local government, as far as practicable, shall evolve a progressive system of taxation. Okay, for the recap, what does it mean by pure LG? P means private person shall not be allowed to collect the tough choice. R for E for and LG for very good children. Okay, that's all for the topic of powers of local government units. Just do not forget the acronyms we have. First is the DEL, the OPO, the ASUS, and pure algae. Now we go to our next interesting topic, which is the term of office of elected local officials. The word term here denotes length of time. Who watched Avengers Endgame here? Raise your hand. Remember the famous line of Morgan, Iron Man's daughter? Exactly! She said I love you 3,000 to her dad as her expression of how much she loves her. Since we will talk about numbers here, I want you to put into your mind the number 3,000. As provided by Section 8, Article 10 of the Constitution, the term of office of elected local officials, except barangay officials, which shall be determined by law, shall be first, 3 years, except barangay officials. 0, no official shall serve for more than 3 consecutive terms. And the infinity sign or 2 zeros to make it 3,000 is that the continuity of his service for the full term for which he was elected shall not be interrupted by voluntary renunciation of the office. And that's it, that's the 3,000. Now to check if you are still with me, try to think of an answer for this question. What evil will possibly happen if there will be no limit to re-election of our public officials? 10 seconds to think for that. Now, the drafters of our Constitution agreed about the possible evils if there would be no limit to re-election. Notwithstanding their conflicting references on whether the term limit would disqualify the elected official perpetually or temporarily, they decided that only 3 consecutive elections to the same position would be allowed. Thereafter, the public official can once vie for the same post provided there be a gap of at least 1 term from his or her last election. Now, the Supreme Court in Abondo v. Comelec held that to constitute a disqualification to run for an elective local office pursuant to the 3,000 rule we have just discussed, the following requisites must concur. First, that the official concerned has been elected for 3 consecutive terms in the same local government post. And second, that he has fully served 3 consecutive terms. For better understanding of the provision, the following cases are of help. In Borja v. Comelec, it was held that the assumption of the position through succession, the service for the unexpired portion of the term, cannot be treated as 1 full term. In Montebon et al. v. Comelec, When succession is by operation of law, an official may run again for the same position he held prior to his assumption. Number 3, in Lozanida versus Comelec and Dizon versus Comelec, it was held that when a candidate is proclaimed as winner for an elective position and assumes office, but was ousted through election protest, an interruption for any length of time breaks the continuity of service. In Ong versus Alegre and Rivera versus Comelec, when an official is defeated through an election protest but has already served the full term for the said office, his loss is not an interruption of his term. While in Latasa versus Comelec, the abolition of an elective local office due to the conversion of a municipality to a city does not interrupt the continuity of service. In Adumeyo versus Comelec, an elective local official who has served for 3 consecutive terms and who did not seek for elective position but later won in a recall election had an interruption of service. And in Aldovino Jr. versus Comelec, it was held that preventive suspension of an elected official does not interrupt the term. So that's all for the total term of elective local officials. Just do not forget Morgan's famous line, "I love you 3,000, where 3,000 stands for 3 years except for barangay officials who shall be determined by law. 0 means, and infinity sign. Okay, very good children. Now my last topic is about local legislative bodies. Local legislative bodies, or sanggunians, are vested with the power of local legislation. Thus, sanggunians have the authority to enact ordinances, approves resolutions, or appropriate funds designed to deliver basic services and facilities and promote the general welfare. But what are these sanggunians? Consider the table to better grasp the concept of sanggunian. Okay, in provincial level, we have the Sangguniang Panlalawigan presided by Vice Governor. In the city level, we have the Sangguniang Panlungsod presided by City Vice Mayor. And in municipal level, we have Sangguniang Bayan presided by Municipal Vice Mayor. And lastly, for barangay level, we have Sangguniang Barangay presided by Punong Barangay. And that's all for my report. I hope you have learned something from me. Thank you.
Hello everyone! Now that we have understood the different constitutional commission, local government, and their distinctive functions, we shall proceed to the accountabilities of public officers. In this segment, we shall learn the what, who, how, and why. What is a public office? A public office is the right, authority, or duty created and conferred by law by which for a given period, either fixed or enduring at the pleasure of the creating power, an individual is invested with some sovereign power of the government to be exercised by him for the benefit of the public. Section 1, Article 11 of the Philippine Constitution provides that a public office is a public trust. Public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, efficiency, act with patriotism and justice, and lead a modest lives. What is meant by public office is a public trust. The basic idea of government in the Philippines is that of a representative government, the officers being mere agent and not rulers of the people, where every officer accepts office pursuant to the provisions of the law and holds the office as a trust for the people whom he represents. What does the command to lead modest lives entail? Even a public officer is independently wealthy, he should not live in a manner that flaunts wealth. Who is a public officer? A public officer is a person who holds a public office. How is public office created, or how does one acquire title to public office? A public office may be created by the Constitution through a law in a manner either by appointment, contract, or election. Modes and kinds of appointments. P stands for permanent. This is extended to a person who meets all the requirements for the position which the former is being appointed. T stands for temporary. This is extended to a person who may not possess the requisite qualifications or eligibility that is revocable at will without necessity or just cause or investigation. R stands for regular. One made by the President while the Congress is in session takes effect only after confirmation by the CA and once approved continues until the end of the term of the appointment. A stands for ad interim appointment. One made by the President while Congress is not in session. It takes effect immediately but ceases to be valid if disapproved by CA or upon next adjournment of Congress. What are the requirements for public office? Number 1, the eligibility. It is the state or quality of being legally fit or qualified to be chosen. Number 2, the qualifications. It refers to the act which a person before entering upon the performance of his duties is by law required to do, such as taking and often subscribing to filing an official oath. Under this are the citizenship and oath taking of office. Does a public officer has restrictions? The answer is yes. Under disabilities and inhibitions of public officers. For example, in legislative department, members of Congress are not allowed to appear as counsel in any court, electoral tribunal, quasi-judicial, or other administrative bodies. Shall not be interested in any contract, franchise, special privilege by the government or any agency or instrumentality. Shall not intervene in any matter before any office of the government for his benefit or where he may be called upon to act on account of his office. In the executive department, the president, vice president, member of the cabinet, and their deputies or assistants, unless otherwise allowed by the Constitution, shall not, during their tenure, hold any office or employment, directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise, special privilege by the government or any agency or instrumentality, avoid conflict of interest in the conduct of their office. Likewise, members of the Constitutional Commission shall not hold any other office or employment, engage in the practice of any profession, or in the active management or contract of any business which in any way may be affected by the function of his office, and be financially interested directly or indirectly in any contract with or in any franchise or special privilege granted by the government or any agency or instrumentality. The same restrictions apply to the Ombudsman and his deputies during his term. Other prohibitions imposed on public officers. Prohibition against solicitation of gifts. Prohibition against partisan political activities. Prohibition against engaging in strife. Restriction against engaging in the practice of law. Prohibition against practice of other professions. Restriction against engaging in private business. Restriction against accepting certain employment. And restriction on multiple office employment in the government. Powers and duties of public officers classified as: Number 1, expressly conferred upon him by the act appointing him. Number 2, expressly annexed to the office by law. And number 3, attached to the office by common law as incidents to it. The doctrine of necessary implication states that all powers necessary for the effective exercise of the express powers are deemed impliedly granted and or vested to the public officer. Duties of public officers are: number 1, to be accountable to the people. Number 2, to serve the people with utmost responsibility, integrity, and efficiency. Number 3, to act with patriotism and justice and to lead modest lives. Number 4, to submit a declaration under oath, his assets, liabilities, and net worth upon assumption of office and as often thereafter as may be required by law. Number 5, to owe the state and the Constitution allegiance at all times. Are public officers immune? General rule: public officers in the performance of their public functions are not liable to third persons. The public officers may be liable criminally, civilly, and administratively on the following nature. Number 1, nonfeasance. It is a neglect to perform an act which the officer's legal obligation to perform. Number 2, misfeasance. The failure to observe the proper degree of care, skill, and diligence required in the performance of official duty. And number 3, malfeasance. It is the performance of an act which the officer had no legal right to perform. The doctrine of command responsibility provides that a superior officer is liable for the acts of his subordinates in the following instances. Number 1, he negligently or willfully employs or retains unfit or incompetent subordinates. Number 2, he negligently or willfully fails to require his subordinates to conform in prescribed regulations. Number 3, he negligently or carelessly oversees the business of the office as to give his subordinates the opportunity to default. Number 4, he directed, cooperated, or authorized the wrongful act. And number 5, the law expressly makes him liable. What happens to a high-ranking public officer who is alleged to have done impropriety in his office? The answer is they can be subject to impeachment, which is a method of removing any person handling government position of high authority, prestige, and dignity with definite tenure for causes related to their conduct as public official. The Constitution provides that the following are impeachable. Number 1, the President. Number 2, Vice President. Number 3, members of the Supreme Court. Number 4, members of the Constitutional Commission. And number 5, the Ombudsman. What are the grounds for impeachment? Number 1, culpable violation of the Constitution. Number 2, treason. Number 3, bribery. Number 4, graft and corruption. Number 5, other high crimes. And number 6, betrayal of public trust. All these grounds must have been committed in the exercise of their functions as public officers. What are the effects of conviction in impeachment? First is the removal from office. Second, disqualification to hold any other office under Republic of the Philippines. And third, party convicted shall be liable and subject to prosecution, trial, and punishment according to law. The Ombudsman. The Ombudsman is the constitutional body created after the fall of Marcos regime with full powers to investigate and prosecute public officials like me for crimes or violation of laws, especially graft and corruption practices. As protectors of the people, the Ombudsman and his deputies shall, number 1, investigate any act or omission of any public official or employee, office, or agency which appears to be illegal, unjust, improper, or inefficient. And this can be done by the Ombudsman on its own or upon complaint. Number 2, the Ombudsman shall direct any public official or employee or any government subdivision, agency, or instrumentality, as well as any government-owned or controlled corporation with the following charter: A. To perform and expedite any act or duty required by law, or B. To stop, prevent, and correct any abuse or impropriety in the performance of duties. Number 3, direct the officer concerned to take appropriate action against the public official or employee at fault, recommend the latter's removal, suspension, demotion, fine, censure, or prosecution, and to ensure compliance therewith. Number 4, direct the officer concerned in any appropriate case the subject of such limitations as may be provided by law to furnish it with copies of documents relating to contracts or transactions entered into by his office involving the disbursement or use of public funds or properties. The Ombudsman can also report any irregularity to the Commission on Audit for appropriate action. Number 7, the Ombudsman determines the causes of inefficiency, red tape, mismanagement, fraud, and corruption in the government and make recommendations for their elimination and the observance of high standards of ethics and efficiency. Number 8, the Ombudsman promulgates its rules of procedure and exercise such other powers or perform such function or duties as may be provided by law. The Ombudsman also administers oaths, issues subpoena, and subpoena desisticum, and take testimony in any investigation or inquiry, including the power to examine and have access to bank accounts and records. It punishes for contempt in accordance with the rules of court and under the same procedure and with the same penalties provided therein. It delegates to its deputies or investigators or representatives such authority or duty as shall ensure the effective exercise or performance of the power, functions, and duties herein or hereinafter provided. And finally, the Ombudsman investigate and initiate proper action for the recovery of ill-gotten and or unexplained wealth amassed after February 25, 1986 and the prosecution of the parties involved therein. The Ombudsman are composed of the following: the Ombudsman or the Tanugbayan, the overall deputy, and the deputy for military establishment. The Ombudsman and his deputies has the following qualifications: A natural-born citizen of the Philippines. B, at least 40 years old at the time of appointment. C, of recognized probity and independence. D, a member of the Philippine Bar. C, must not have been a candidate for any elective office in the immediately preceding election. And F, for the Ombudsman, he must have been 10 years or more a judge or engaged in the practice of law. The Ombudsman has the following disqualifications and prohibitions. He cannot hold any office or employment during his tenure. He cannot engage in the practice of any profession or in the active management or control of any business which may be affected by the function of his office. And he cannot be financially interested, directly or indirectly, in any contract with or any franchise or privilege granted by the government any of its subdivisions, agencies, or instrumentalities, including GOCCs or their subsidiaries. Ombudsman has 7 years term without reappointment, and they shall be qualified to run for any office in the election. The Ombudsman and his deputies shall have the rank of chairman and members respectively of the constitutional commissions, and they shall receive the same salary, which shall not be decreased during their term of office. The Sandigang Bayan. The Sandigang Bayan was created under Presidential Decree 1606 as amended by Republic Act 8249. It is a special court of the same level as the Court of Appeals and possessing all the inherent powers of the Court of Justice. It is composed of the presiding justice and 14 associate justices who shall be appointed by the President. The Sandigang Bayan has the following exclusive regional jurisdiction. Number 1. Over the following crimes when committed by public officials and employees classified as salary grade 27 or higher. A. Violations of Republic Act 3019 and 1379. B. Crimes committed by public officials and employees embraced in Chapter 2, Section 2, Title 7, Book 2 of the Revised Penal Code. And C. Other offenses or felonies, whether simple or complex, with other crimes committed in relation to their office. Number 2. Civil and criminal cases filed pursuant to and in connection with the Executive Orders Number 1, 2, 14, and 14A issued in 1986. Provided that the Regional Trial Court shall have exclusive regional jurisdiction where the information A. does not allege any damage to government or any bribery, or B. alleges damage to the government or bribery arising from the same or closely related transactions or acts in an amount not exceeding 1 million pesos. In the absence of any allegation that the offense charged was necessarily connected with the discharge of the duties or functions of the public officers, the ordinary court and not the Sandigang Bayan has the jurisdiction to hear and decide the case. What determines the jurisdiction of the Sandigang Bayan is the specific factual allegation in the information that would indicate close intimacy between the discharge of the accused official duties and the commission of the offense charged in order to qualify the crime as having been committed in relation to public office. The relation between the crime and the office must be direct and not accidental. That is, the relation has to be such that, in the legal sense, the offense cannot exist without the office. In the Recovery of Ill-Gotten Wealth, Section 15, Article 11 of the 1987 Constitution states that the right of the state to recover properties unlawfully acquired by the public officials or employees from them or from their nominees or transferees shall not be barred by prescription, laches, or estoppels. This provision applies only to civil actions for recovery of ill-gotten wealth and not to criminal cases. Thus, prosecution of offenses arising from, relating, or incident to, or involving